Okay, I'm Ian Charles of Wizards. I'm here with Jeremy Holt. Jeremy, introduce yourself.
Hi, I'm Jeremy Holt. I'm a partner in a law firm called Holt Commercial Solicitors based in Swindon. I specialise in commercial law and in IT law.
Right, now one of the things that we have touched on in the previous video has been the ownership of data. Now, you said something which I found quite shocking.
Did I? Which particular thing was that?
Who owns data and how can data be owned? What's the difference between data and information?
Right. Okay. Sounds like a philosophy question.
Well, it's
Right.
deliberately
Okay.
catching those two. Answering whatever form you'd like.
Discuss.
Yes.
Right. Okay. It is a widespread
Marks
myth.
will be awarded for it.
Well, I live in hope. It is a widespread myth that data can be owned. In fact, data can't be owned. I mean, there have been prosecutions under the Theft Act that failed because people had taken data, and it's not capable of ownership. Therefore, if I have information, if I have data that I want to share with you, but I don't want you to pass it on to other people, before I give you that data, I should get you to sign a confidentiality agreement. Because then contractually you and I have agreed that you wouldn't pass it on to third parties, or that you wouldn't use it for your own purposes or inappropriate purposes, and therefore I can then sue you on the basis of the contract. Now, there are sometimes implied or express duties of confidentiality in relation to information. Although, as a lawyer, if I get a letter from another lawyer and it refers to an implied duty of anything, I generally laugh like a drain at that point, because I think if all they can come up with is an implied duty, then you haven't got very far.
Yeah.
So it's much better to have an express, i.e. a written, duty of confidentiality. I have to say I've been very impressed with British industry and commerce, because most people do abide by confidentiality agreements, and they're signed quite frequently. And most of the confidentiality agreements that I advise on, or that I draft myself, are mutual ones, because although I might be giving you a lot of confidential information, the questions that you ask me in getting that information might give away what you're proposing to do in future. And also, my experience with clients is if an agreement is mutual, people are much more happy to sign it, because they think if you're prepared to have this used against you as well as for you, then it can't be too bad.
Right.
It shows you're showing your commitment by doing it. So I'd strongly advise people to use mutual confidentiality agreements, i.e. they apply to both people, because even the recipient might ask, do you have any more information about Romania, or do you have any more information about midwives or something? And you suddenly realise, well, of course, that's the area that they're going to be going into. That's why they're asking for this confidential information.
Yeah. So, what's the distinction between data and information? Data, as I understand it, is just numbers. It's just
Not
numbers.
necessarily numbers.
Well, or numbers relating to, or numbers indexed against something else.
Yes, that's true.
So it's kind of
It's unprocessed information.
yes, it's just of a sample.
Information is when that data has been turned into something of value.
Exactly.
Yeah.
Exactly. So the information. So data is merely just and the accumulation of just general stuff, isn't it? Okay. So and what does that mean for what does that mean for someone who say, for example, walks off with a customer list?
Right. Okay. If somebody walks off with a customer list,
Which is information.
oh yes.
Who are they? Who do they work for?
Yeah.
What do they buy?
Yeah, well, there are two aspects to that. If in the employment contract that they had there was a confidentiality clause, there would then be what lawyers would call an express obligation of confidentiality, i.e. it's written down and it's there. And the courts are very heavy on coming down on people who do what's called springboarding, that you move away from one place but you springboard to another place, you take advantage of the work that they've done. So customer lists of themselves are regarded by most courts as being confidential. Now, if there wasn't an employment contract, but it was known by the person that this was quite detailed stuff, I think there would, in those circumstances, be an implied duty of confidentiality, which isn't as good as an express duty of confidentiality, but it's something that's there. Now, One of the things which I've known people do is, if there is a customer list, to put their mother-in-law in there, or to put some what's called sleepers in there, who aren't really customers, but if they suddenly get a letter from the new company that the former employee has moved to and has obviously copied the customer list, if there's somebody, your street is, you live at number 42, but you get a letter addressed to 42A, which will be buried in there. There is no 42A because there's only a 42. So why did you address a letter to 42A? The reason that you did that is because you copied that customer list. It's a bit like the Ordnance Survey putting a few false contour lines on their inch to the mile maps, so that when people copy them, they can show that it was copied from that particular source. So you can bury some sort of little time bombs in there that can go off later if somebody makes an illicit copy.
That's actually common practice when you buy a mailing list.
Yes.
You buy a mailing list.
They're sometimes called seeds.
Yeah. It's just kind of non-existent person at domainon.com.
Yeah.
So that tends to be the way that works. Okay, so there are ways of protecting yourself, but look at it from the other point of view. Say you're one of these devilish people who's a salesman. How do you we've all taken or customer lists are known to be portable, and you do walk from one job to another in the expectation of taking a certain amount of business with you, particularly if you know that the first employer is failing.
Yeah. Well, if the first employer fails, there's very little that they can then do about it, because there's no business to protect in those circumstances. So the best news for the departed employee working for the new employee might be that the old business has failed, and therefore the liquidator or the administrator is unlikely to enforce any rights that they might have in those circumstances. But there is a triangle here, because if the salesman takes the data and starts using it for the purposes of the new employer, when I've acted for the person whose data has been stolen in those circumstances,
in spite of the fact it's impossible to steal
no, sorry, that's very sharp of you to pick me up on that. You can't own the data. The thing is that lawyers, in both agreements and in normal conversation that I hope we're having at the moment, do entertain the fiction that it can be owned, because it just works better in those circumstances. So it does annoy me sometimes that so few people do actually understand that you can't own data, but the fiction is entertained to allow different things to happen.
But that's just to allow to give you a frame of reference in which to discuss what's actually happened.
Yeah.
So yes, we know that data or that information can be removed, can be used elsewhere. And what about data that isn't written down or held on a?
When you talk about know-how, I mean, it is very difficult to prevent a member of staff who's built up know-how, i.e. they haven't copied anything, they've only got what's in their head. So know-how basically is transferable.
But doesn't that date back to the original restraint of trade thing, which was about hairdressers?
Yes, a lot of the cases are about hairdressers, but they're mostly geographical, because people won't travel long distances. Obviously you don't travel long distances to have your haircut. would appear not.
No. Well, joking aside about this, I mean, the traditional way of a hairdresser working is you rent a chair.
Yes.
So you're effectively paying the owner of the shop
yeah.
for the privilege of cutting hair in his shop, and your clients come and see you.
Yeah, you see, with those kinds of very geographically delineated businesses, the Victorian cases were about hairdressers and also milk delivery men, because there would be a choice of people you could get your milk delivered by.
Right.
Which is why the geographical area of the restriction has got to be quite narrow and not excessive. Less is more on this. I spend a lot of my time with clients trying to persuade them to put smaller restrictions, fewer restrictions in, because they're much more likely to be enforceable. 6 months is not really a problem so far as an employment contract is concerned. Sometimes a year will be a year. It's often a year in relation to insurance, because insurance is renewed once a year. So a 1 year period would cover all the customers, one renewal.
Right.
But it's very difficult to get any restriction in an employment contract, really, that would work for anything beyond a year.
Right. Right. So yeah. So that, and that's about, and that's also about the enforceability, isn't it? Are you actually going to enforce it, and to what degree will you enforce it?
Yeah.
And what will it cost you to enforce it?
Well, I'm afraid the bad news is if you wanted to go and get an injunction to stop person using that will cost many thousands of pounds. Now, whether you want to spend that, and again, I spend a lot of time trying to discourage people from doing that, because I say, yes, you can get even, you can stop that from happening and all the rest of it, but do you actually make any money out of it? You don't. And wouldn't it be better to use that money for the other things that you do, where you actually make money from it? Sometimes people do it as a kind of example to the other members of staff, or every 10th one they do, just to sort of remind them that they've got the capability of doing that.
Yeah, so or hire a better replacement.
Yeah.
And I mean, lawyers move as well, don't they? The time was when you became a partner, and that was where you sat.
Yeah.
I mean, the whole point with partnerships is it's not a particularly efficient way of running a business, is it?
No, I mean, I was looking at our own employment contract in my own firm the other day, and we have two restrictions. We have a restriction that if you leave us, you can't act for a client that you've worked for in the previous 12 months before you left, again, within the first 12 months after you go.
Right.
And I think that we've got something which says that you can't set up a new law firm, or you can't. Yes, I think you can't go and work for a law firm that's within 5 miles of our office. Although I think that's probably unenforceable, to be honest, because if they're working in a law firm that does something that's totally different from what we do, because we only do business law.
Yeah.
If they did sort of
family law or something.
Yeah. I mean, why would we worry about that? So, I mean, apart from that, there would be the confidentiality obligation. So, if you were taking a lot of confidential information, you'd be in breach of that. I mean, often where there's a problem, it's not so much the restrictions that are of value to the employer, it's the straight breach of confidence under the confidentiality clause that's of great help.
And what constitutes a confidential information? Do you mean things like somebody's name or their phone number, which is held on your personal mobile?
Yes, it's a range, it's a spectrum. I mean, let's at the top of the spectrum, at one end of the spectrum, I would say something like future pricing plans over the next 12 months,
right.
Which would be really hot stuff. It would be weaknesses that the company had in relation to what was going on that weren't yet publicly known.
But that's surely that's as much as anything. That could be if they're publicly listed. That could be.
If they're publicly listed, I was thinking more in terms of private companies.
Yeah. If they're publicly listed, that's a different matter, isn't it? So weaknesses, but straightforward things like a person's name or their phone number or their address, roughly where they are. I mean,
Well, some of that stuff you might be able to remember in your head, in which case it makes it more difficult if you could remember it in your head. There was a case just after the war where there were two companies making transistors, and one of the restrictions was that you couldn't go and work. If you left one of the two transistor companies, you couldn't go and work for the other transistor company. You couldn't work for any transistor company in the UK, but there were only two. And they said, well, look, this is unfair because I've left one and there's only one other one and I'm not allowed to use it. But the court backed it up and they said, no, in those circumstances the market is so narrow, you can say you can't work for any transistor company in the UK.
Yeah, that's effectively granting a monopoly, isn't it? It's a very
yes.
It's complete.
It was only for a particular period, a period of 6 months or a year, because these things there's all the restrictions, even the confidentiality side, run out after a particular period of time. The last one to run out is the confidentiality, because that will run out after 5 or 6 years. But the other restrictions in an employment contract, very difficult to get a restriction to last for more than 6 months or a year. Once you get past a year, then apart from confidentiality, it wouldn't be operative.
Of course, I always wait until before picking the phone up to a former employer's customers. You just wait for the cheque to clear.
Do you? Right. How quaint that they pay by cheque, but yes.
It's a metaphor.
Yes. Sometimes people have it marked in their diary as to what the 365th or the 180th day is, when they can actually do that. Or sometimes they actually hold a party at that point that they can then invite everybody to. It's a bit obvious in those circumstances, but yeah. Now, we enforce them in this country, but in some parts of the world, as you probably know, certainly California, that you're not allowed to have post-termination of employment restrictions. And some people have said that was why Silicon Valley got off the ground in California, because they could move from one place to another.
But then that is equally matched by the fact that they have, if ever you've seen an American contract of law, or sorry, contract of employment, it will state explicitly, your employment may be terminated any time for any reason.
Oh yes, a red slip or whatever it's called.
Yeah, so that there is there's no notice period. There's nothing.
No. I accept that. I think, as far as I know, over in California they still enforce confidentiality obligations. It's just the restrictive covenants that they don't allow.
Right.
And the restrictive covenants in this country, to be honest, have got narrower over the years. When I first started in law 40 years ago, you could get away with 2-year employment restrictions. You'd never be able to get away with those now.
But were they enforceable, or were they enforced?
I think they were enforceable. Whether they were enforced or not is another matter. You could take the argument, and some clients have told me that this is the case, that they want to put in long restrictions there because the employees believe that they're enforceable, and that the employer knows well that they're not enforceable, but if it gets people to keep their heads down. Many years ago I was in the TA, we were always told if we were ambushed, always just let off 2 rounds. You don't even need to point at the people who are ambushing you, just fire them in the air if necessary, because the people ambushing you will probably put their head down if they hear a couple of rounds going off.
Right.
You just do it for show.
Absolutely. Okay, well that's actually really interesting. But
Good,
so
I'm
thanks
so
very much,
pleased.
Thanks. Okay, anything else we want to add?
No, I'd better leave on a high.
Thanks very much.
Okay,
Cheers.
cheers.
Bye bye.